speak up. Okay. Directing the Capital Preservation Committee to develop approved plans for a mural honoring the 1st Kansas Colored Volunteer Infantry. So with reviser, please revises.
Good morning, committee. This is going to sound very familiar. Senate Bill 39 would amend KSA 75-2264 to authorize the Capital Preservation Committee to develop and approve plans to place a mural in the Capitol honoring the 1st Kansas Colored Voluntary Infantry Regiment. Senate Bill 39 would authorize the Secretary of Administration to receive monies from grants, gifts, contributions, or bequests made to finance the creation and construction of the memorial. The memorial would not require any public funds for its creation or its construction. Senate Bill 39 would establish in the state treasury the 1st Kansas Colored Voluntary Infantry Regiment Fund. Expenditures from the fund would be for the purpose of creating and constructing the memorial. Senate Bill 39 would take effect upon publication in the statute book, and I can stand for questions.
Are there any questions? I have one. Is this the same bill as 2088?
It is.
Same dots, same commas, same everything.
Yes, sir.
Good. Easy. Thank you. Proponents, Senator Bowers. Glad to have you.
Good morning, my House friends and Chairman. Yes, you heard this just a couple of weeks ago, and we sat in the back audience with you as well. I do want to introduce a couple folks with me. Patrick Zollner is the director of the Historical Museum, or interim, and then we have Frank Berman in the back. He's the Department of Administration, so I call him boots on the ground guy to help keep us straight on what we do in the building. And Patrick is the chairman of our Capital Preservation Committee. So everything the reviser just told you is what I have in my first two paragraphs. I'm not going to repeat that. You did hear this bill. I think you have an excellent idea of what this is all about. I do want you to look at the third paragraph of my testimony, because there's something very interesting in here. And you say, why has it taken 20 years to have this project go forward? And now we know why from research from Melissa Rennick. And you can see in the October 25th minutes, if you go back and I give the instructions on what tabs that you push, it took her 15 minutes in committee to tell us why this hasn't happened. And it kind of just got shuffled along in all these committees until it merged into the Capital Preservation Committee. And our committee normally meets one time a year, and we have the ideas brought forward. So we had a subcommittee to see what the holdup was and how we get this going again. So after 20 years, and here's the history of it, you can see it was Senate Bill 660 that started this. So we all think it's way past time that we make this happen. So we're so close now. And then in our last meeting, if you look at our minutes, we have a subcommittee already chosen. So that subcommittee will do some preliminary work, like where different locations where this could be at, because that's not set. And then it is a long process of choosing the artist. So a long process. Of course, the funds will have to be raised, which I think we got a good handle on that as well. I do want to talk just a little bit about the Capital Preservation Committee, because last year when we were doing the women's suffrage bill, someone in a committee said, what does this committee do? Anything that happens on this complex, outside and inside, goes through this committee. You can't just go stick a plaque on a wall. It has to be approved through this committee, which is really proper. So it controls the heritage, everything about this building that we just love, we can preserve in this committee. So if you look down at the bottom, you can see Patrick is our chairperson, or the two senators, the two House members, and Frank, like I mentioned, is like our advisor that he's very key in this of what we can and can't do on the walls or locations for any specific reason. So I do believe that's all I have, Chairman. And you're right, it's 2088 to the word, and it passed unanimously in the Senate off the consent calendar. I want you to run it across the House floor, though, so we can talk about this great project. And I'm ready for questions if you have any.
Are there any questions? Yes, sir. Representative Collins.
Thank you, Mr. Chair. And this might have been covered already in our previous hearing, and if so, I apologize, but is there a specific spot on the wall that's been chosen yet?
Not yet. In fact, Patrick and I walked around looking for different locations that it could be, but nothing ever was put down in all these 20 years of shuffling through committees of where it could be. I've heard rumors of where it could be, but there's the subcommittee will do their tour and work with Frank and Patrick on that. I'm not on this subcommittee, so but I'll help however we can. It's a wonderful project, but 20 years past is way too long. So we all can make this happen this year.
Well, thank you, and thanks to everyone involved in this and we're doing the work to make it happen.
So perhaps you want to walk around and look at all the open walls and report to us. And I'm not sure, Chairman, if Patrick or Frank, if I've missed anything, do you want to add anything? Okay, Patrick spoke to you last time and I was his support staff. So they're my support staff today.
Thank you. Any other? Representative Butler.
Senator, thank you very much. This bill, I think is a great bill to get passed. So thank you all for passing it through the Senate. Had a chance to talk to several organizations and individuals about this bill, and they were all very excited about something like this being placed in the Capitol for the first Kansas. So thank you very much.
Yes, and I'm just sad it's taken so long. It just took our subcommittee and some energy, and we can make this happen. And we get to be the year that it gets to go. So I'm excited for all of us on our committees.
Any other questions? Well, thank you.
Thank you, Mr. Chairman.
We'll get this done.
All right. Thank you.
Are there any other proponents? Are there any other proponents? Any opponents? Any opponents? Any neutrals? Any neutrals? A motion, possibly we could get this out today. Representative Johnson.
Mr. Chair, thank you. I would move we suspend the rules and proceed to emergency action.
Second by Representative Thompson. That means that instead of listening to this and looking it over for 24 or 48 hours, we'll just work on it today for all the freshmen. Since we've already heard it, sounds like a reasonable suggestion. So we've had a motion and a second to vote on the motion. All in favor, say aye. All opposed? The motion has passed. Now back on the bill. Do we hear a motion to move the bill? Representative Johnson.
Yes, thank you, Mr. Chair. I would move that we pass favorably our mural bill.
Do we hear a second? Second by Representative Thompson. You've heard the motion and the second to move Senate Bill 39 out today. All in favor, say aye. All opposed? The bill has passed. Thank you. Very good. Now we're going to open the hearing on House Bill 2392, updating the Kansas Code of Military Justice relating to certain definitions, unlawful acts, and punishment required thereof. Would the reviser please give us a briefing?
Hello again, committee. House Bill 2392 updates the Kansas Code of Military Justice, the KCMJ, relating to definitions, unlawful acts, and punishment requirements. House Bill 2392 provides new sections of law and updates existing statutes to conform with the Uniform Code of Military Justice, or the UCMJ, and modern drafting practices. Section 1 requires that no member of state military forces be held in confinement with enemy prisoners or other foreign nationals who are not members of the armed forces. Sections 2 and 3 address the appeal procedure when a member is punished under KSA 2301, and when a civilian court may try a serious crime committed by a member subject to the KCMJ. Sections 4 and 5 address prohibited sexual conduct, including conduct with a specially protected junior member of the armed forces, and when submission to or rejection of such sexual advances impacts the victim's job, pay, or career. Sections 6 and 7 address the conduct required of a sentinel or lookout. Sections 8, 9, 10, 11, and 12 address the creation of false writings, impersonation of a senior officer, unauthorized use of insignia, and tampering with mail. Section 13 requires that a member subject to the KCMJ be punished at the direction of a commanding officer if such member leaves the scene of a car accident without providing either assistance or personal identification. Section 14 requires that a member subject to the KCMJ be punished at the direction of a commanding officer if such member discharges or brandishes a firearm under circumstances that may endanger a human life. Sections 15 and 16 address the crimes of simple assault, committing a violent offense, or violating a protection order. Section 17 requires that a member subject to the KCMJ be punished at the direction of a commanding officer if the member either communicates a threat or maliciously communicates a false threat of injury by explosive, a weapon of mass destruction, a biological agent, or a hazardous material. Section 18 requires that a member subject to the KCMJ be punished at the direction of a commanding officer if such member wrongfully distributes intimate visual images or visual images of sexually explicit conduct. Section 19 requires that a member subject to the KCMJ will be punished at the direction of a commanding officer if they falsely testify after taking an oath. Sections 20, 21, 22, 23, and 24 address conduct that intends to impede the due administration of justice, including the concealment of another person's crimes, wrongfully refusing to testify as a witness, or impeding a proper search and seizure of property. Sections 25 and 26 address the bribery of an official or a person with official duties. Sections 27 and 28 address the crimes of fraud and extortion. Section 29 requires that a member subject to the KCMJ be punished at the direction of a commanding officer if such person, without legal justification or authorization, knowingly and wrongfully views, records, broadcasts the private area of another person without such person's consent. Section 30 requires that a member subject to the KCMJ will be punished at the direction of a commanding officer if such person takes or threatens to take an adverse personnel action with the intent to retaliate against any person planning to report a criminal or military offense or make a protected communication. Section 31 allows Army Regulation 2710, Military Justice, Air Force Instruction 51201, Administration of Military Justice, and Air Force Instruction 51202, Non-Judicial Punishment, to be used to enforce the KCMJ to the extent that they are consistent with the KCMJ. Section 32 requires that nothing in the KCMJ precludes administrative action against a person subject to the KCMJ for a military or non-military offense. Section 33 states that the provisions of the KCMJ are severable, and that if any part of the KCMJ is found to be unconstitutional or invalid, that finding does not affect the applicability or enforcement of the rest of the KCMJ. Additional changes to the provisions of HB 2392 update Chapter 48 of the Kansas Statutes Annotated to comply with the UCMJ and modern drafting practices. House Bill 2392 would take effect upon publication in the statute book. And I can stand for questions.
Thank you. That was very easy. Are there any questions? Yes, Representative Younger.
Thank you, Mr. Chair. How often are these updated? Is this a yearly process or?
These statutes, I believe, had not been updated since the 1980s.
Representative Ruiz.
I don't know if you can answer this. On line 15 in the bill, it talks about the prohibited sexual activity. Oh, it was
Sorry, what
page
page?
3.
Okay, thank you.
It's 3 under section 4, I think it is. Line 15, prohibited sexual activity. It doesn't really give a definition of what that is. What do you know what that is?
I do not. I apologize. Under those military regulations, I do not.
Thank
Representative Weigel.
Thank you, Mr. Chair. Thank you for your presentation. I didn't see anything in here, at least I don't policy, on non-judicial punishment, what when I was in the military would call Article 15. Is that included in this?
I believe when we were referencing at the beginning of the presentation, 482301, that is the non-judicial punishment
So
statute.
that includes.
Mhm.
Thank you. Thank you, Mr. Chair.
Any other questions? Any other questions? Thank you very much. Our first proponent is Lieutenant Colonel Micklewee, Judge Advocate. Did I pronounce that right?
We have 4 judge advocate lawyers in the room. Everybody ought to be a little bit nervous.
I got chosen because I'm the friendliest one. So no one needs to be nervous when I'm talking. Mr. Chairman and committee members, my name is Lieutenant Colonel Jacob Mackley. I'm a judge advocate for the Kansas National Guard. And it's my pleasure to speak to you today about our efforts to modernize the Kansas Code of Military Justice, as codified in Chapter 48 of the Kansas statutes. I truly appreciate this opportunity to testify in support of House Bill 2392 and on behalf of the Adjutant General's Department. Generally, when National Guard members serve pursuant to federal courts, they're subject to the Uniform Code of Military Justice under Title 10 of the United States Code, which outlines the role of the armed forces of the United States. For most National Guard members, however, they're going to serve the bulk of their time in a Title 32 status under United States Code, which outlines the role of the National Guard of the United States and otherwise applies during drill weekends and annual training. So think your normal 1 weekend a month, 2 weeks a year. So your traditional training is we're always going to fall under the KCMJ. During service under Title 32, members are bound by Army regulations and Air Force instructions, respectively, but also under the Kansas Code of Military Justice. Since its enactment in 1951, the UCMJ has undergone several major revisions, where once the KCMJ and UCMJ coexisted with similar language, the KCMJ has undergone only minor revisions since its enactment in the early 1900s. Consequently, the KCMJ needs updating to serve the current needs of commanders. These proposed changes include consolidating language from various provisions of Chapter 48 to avoid unnecessary and duplicative language, updating and adding definitions to match those contained in the UCMJ, ensuring overall consistency with the UCMJ and model state codes of military justice that have been enacted by our sibling states, and updating language to modernize non-judicial punishment proceedings to bring this oft-used disciplinary process in line with other military justice changes, and updating KCMJ punitive articles to mimic current UCMJ punitive articles while continuing to exclude serious felonies, i.e. murder, manslaughter, rape, robbery, maiming, sodomy, arson, extortion, and burglary, which remains under the purview of civilian courts. Modernizing the KCMJ ensures that the men and women of the Kansas National Guard are subject to statutes that are consistent with the UCMJ, Army regulations, and Air Force instructions, giving commanders the tools they need to properly address disciplinary matters that arise when members are engaged in service of the United States and the state of Kansas. Thank you again for the opportunity to speak today.
Thank you. Are there any questions? Representative Dotson?
Yes, thank you very much. I sent over some questions, and these are not, I think these will be helpful to all of us here, as well as when I present this bill in front of the House. I'll be rather generic. In other words, I just want to present kind of the what this thing does in terms of updating the KCMJ. And so I want to make sure that I'm kind of armed with things. I've been out of this for 20 years. So just a couple of questions on this KCMJ. You know, when I used to use the UCMJ, you had a book there and you could open it and it'd take you to the appropriate article and you could scan through that and your JAG would come down and explain which one the individual was being charged under and read all the specifications and so on. Does that same kind of book form exist for the KCMJ?
So Representative, yes and no. So we have to exist within the confines of how the revisor's office wants statutes constructed. And so it's not going to say like, you know, it's not going to look exactly like the UCMJ does where you're going to have Article 120, Article 119. With that said, you know, I do have this handy cheat sheet that I would be happy to share with you that says, you know, KSAX is the same as UC or mimics or is the same subject matter as Article 120 or Article 119 or Article 118.
That'd be helpful to me personally. You know, I noticed when I was going through this that there are over 120 statutes that are impacted by this, and it's just a little clunky. If that's the way we have to do it, so be it. But I would like every commander to have on his desk some kind of whatever you've got so that,
yes,
you know, when the first sergeant comes in, you kind of know what you're doing and easily without having to do a lot of research.
Absolutely. And I know that this is probably not the most self-serving statement that you'll ever hear from an attorney, but one of our big picture ideas with this revision is to enable commanders to work faster, more efficiently. And so when you take this bill in conjunction with the House bill that we discussed on Tuesday, House Bill 2230, where we strip out court martials and we go almost exclusively to non-judicial punishment, you know, just so this committee has a full grasp of what that means is a non-judicial punishment. We can get this done in 3 days. So from beginning to end, an Article 15 can be done in 3 days, as opposed to, you know, a court martial or a process like that can take months and span into the years. And so part of our idea is, since we're not a standing army and since we only have, you know, contact with most of our soldiers and airmen 2 days a month, 2 weeks out of the year, we want to give our commanders the tools to act quickly, efficiently, and to be able to effect good order and discipline without having to rely on processes that can take months or years. And so the National Guard acts best when it acts decisively, it acts with good order and discipline, and the soldiers and airmen are focused on the mission. And so our hope is that with these two bills in conjunction with one another, we're giving the commanders the tools they need to quickly effect discipline, quickly impact and make sure that justice is served, that anyone who's harmed gets the redress they need, and we can continue on with the mission. So this is designed to make us more efficient and to reflect the fact that we're, you know, 90+% of us are just in a traditional status, and most of the time we're out in Kansas working as plumbers and electricians and like that. So sorry if I spoke too long, but that's
that's great. I think it's good for everybody to hear. And in that regard, when I was reading through this, I know we excised everything that has to do with court martial, but is it intended that someplace in the regulation we talk about a referral process, or is that completely?
So Representative, if there was if this passes, we will not have any court martial process. Now, we would still have the opportunity to do an Article 15 non-judicial punishment. We'd still have the opportunity to administratively separate a soldier who is committed some type of misconduct if it's serious enough. We do have rules and regulations that kind of give us guideposts about how an administrative separation works and how it looks and the rights that the soldier has and how that acts. But that would be what we primarily focus on, would be non-judicial punishment and administrative action.
And then the other things are the ones that were mentioned by the revisor referred to civil court generally.
Yes, and so with civil court, we don't, since we're not a standing army, we don't have, you know, unlike, you know, active duty, we don't have a prison at Fort Leavenworth where we can send people. And so if it's a serious crime, that really needs to be handled by the civilian courts and the district attorneys.
And when in UCMJ, when you're doing Article 15, generally you have the ability to fine, the ability to suspend, the ability to reduce in rank, administratively discharge, and so on. So is this the same under KCMJ? Those same things apply to a commanding officer?
Yes. So the commanding officer is going to have a range of options depending on their rank. So for those who aren't familiar, within the Army, we have a structure of a company commander, which is the lowest level of commander, battalion, which is one higher, brigade. And so the higher you get up in command, the more responsibility and more authority you have. So a company commander is not going to necessarily have the same amount of discretion to impose penalties as a battalion or brigade. And the idea being that as you grow in maturity and wisdom and you have more responsibility, you have more ability to impose more serious punishments. But it's essentially the same. And I don't want to get too much inside baseball here and waste everybody's time. But yes, it's pretty much if you transpose them over the one over the other, it would be the same.
And where is that captured? In other words, the difference between the abilities of a captain, a lieutenant colonel, or a colonel?
So it's somewhere. It's in this bill. It's also in 2048-2301, and then to the extent that we look at Army Regulation 2710, that also spells it out. That also spells it out as well.
In the active services, we have, a standing SJA, particularly at the division level, and he's got a cadre of defense attorneys, a cadre of prosecutors. Is that the same way that you're going to be set up with a state adjutant general or a state judge advocate?
Yes, and actually we have the Army State Judge Advocate, Colonel Jim Seward, and he's here today to help answer questions or correct any mistakes that I might make. And then on the Army and on the Air Force side, we have Colonel Jared Magg. He is a U.S. attorney in the civilian world, so unfortunately he couldn't make it today because he had trial. But then also we have trial defense services. So any soldier who gets notice for an administrative separation or gets a general officer memorandum of reprimand or gets notice for an Article 15 has the ability to work with Trial Defense Service free of charge. Right now in the Kansas Army National Guard, we have 3 TDS slots. We call Trial Defense TDS. And we have 3 slots right now. 2 of those slots are filled. And anytime somebody is going to be encountering non-judicial punishment or certain administrative actions, they have the right to consult and work with Trial Defense Services free of charge.
I think that's an important element for everybody to know, that there's the same ability that exists in civil law inside military justice, so that a soldier has, or an airman has, access to an attorney during these proceedings.
Yes, Representative Collins.
Thank you. I was just wondering, and on to that, say a person in, some armory somewhere is being charged with Article 15 and they wanted to use the services of the defense. Would the defense attorney travel to them, or would they have to go somewhere, or would it be done remotely, like by phone or video?
So it depends. So right now, I would say, in the last 3 years, a lot of that has been done via phone and via, Zoom or Teams or something like that. But it just kind of depends, because, not all soldiers, sometimes soldiers know they've screwed up and they'll just walk in and they'll say, guilty. I did it. I'm sorry. I shouldn't have. But then sometimes the ones who do want to talk with TDS, they'll want to meet in person, and then they'll say, hey, look, I know that I'm only allowed technically 2 days before the first reading, which is when you're notified, and the second reading, which is when the commander does the hearing and makes a decision about whether the soldier is guilty or not. But they'll say, hey, can I please have some extra time? And generally, since we are a part-time force, we'll almost always grant the person more time in order to work with TDS, just because, sometimes just the reality of, someone who's a U.S. attorney or an FBI agent, and they're also in the Guard, they don't, they might need a little bit of extra time to link up with that soldier to represent.
All right. Thank you.
Thank you. Representative Dodson.
Lastly, if you would just kind of summarize for everybody when National Guardsmen are federalized, they fall under UCMJ, and then your normal times, you fall under KCMJ. And maybe if there are any things like natural disasters, when the governor asks you to go out and help people, if there are any differences there. This is Title 10, Title 32 business.
Sure. So, and thank you for the question. Usually, almost like 99.9% of the time. So if we're responding to a Greensburg type disaster or wildfire, we'll be out in a Title 32. We'll be out in a Title 32 status, which is part of why we wanted to make this KCMJ lean and efficient. Because a lot of times when things really matter, you know, a commander is going to have to act quickly, and they're going to have the ability to ensure that their unit, that their people are acting with laser focus on the mission and on the job and on protecting Kansans, and not on things that are going on that would be distracting. So they would be on a Title 32 status, and that's part of what we're looking towards, is empowering commanders more to ensure that good order and discipline and like an unwavering focus on the mission is possible.
Thanks very much. Appreciate it.
Thank you. Representative Younger.
Thank you, Mr. Chair. Just the same question that I asked the revisor. It seems like there's a lot of changes here. Is that normal? Or I'm not an attorney, so it seems like laws are constantly changing. Is it a man-hour issue, or it's not an issue at all?
So if you're talking about kind of the ambitious scope of these two bills, it's just we hadn't addressed it in so long. We try to be as apolitical as possible, and while we respect everything you guys do, we don't come up here very often and ask for this kind of stuff. So when we did, we just wanted to make it as meaningful as possible to make sure that we got it fixed right the first time, and then hopefully we don't have to burden everyone here with more bills in the ensuing years.
Any other questions? Representative Johnson.
Thank you, Mr. Chair. Clarification for the National Guard. So if there's a violation that occurs not off duty, but not serving, they're on their regular lifetime, does this code still impact them at all?
Most of the time, no. So one of the tenets we have in this bill is that they have to be in a drill status for this to apply. Now, that wouldn't necessarily preclude us from taking administrative action. So for example, let's say somebody got arrested for, distribution of drugs. We could still administratively separate them, because we don't need people like that serving in the state of Kansas and serving in the Army. But would we take KCMJ action against them? Not necessarily, not if it happened when that was outside of a duty status. And there's a couple of exceptions to that. Drug use might be an exception, but 99.9% of the time, this really only applies when someone is in a duty status.
Got a question? So I worked a number of cases in criminal justice in Leavenworth County, where I would work with CID on some issues, but that was with full-time personnel. But if it occurred off the post, and then we would get called in, I guess, is that different than your setup here?
So normally what we do in situations when soldiers get arrested, when they're not in a duty status, or they're not in like on an armory, or they're not at Leavenworth, is we follow along and kind of wake behind the law enforcement and the district attorneys. We find out how that case is terminated, and then we'll take appropriate administrative action. So, if someone commits a serious felony, we'll do an administrative separation, but based upon the civilian conviction, not based upon our own investigation or our own determination. But so there's an Army regulation that controls administrative separations for enlisted, and it says that if you have a conviction for a civilian conviction and it meets certain thresholds, then we can separate the soldier. So that's usually how we handle things.
Do you have an investigative agency with National Guard? I worked with CID, but do you have one? If you don't?
We do not. So sometimes we get to use CID if an offense was occurred on a federal installation, And National Guard Bureau has an entity called the Office of Complex Investigations, and they will come and investigate certain allegations for us, but we don't control that. All we do is invite them to come and investigate certain investigations, but we don't really have an investigative branch within the Kansas National Guard.
Thank you very much. Thank you, Mr. Chair.
Senator Weiss.
In the bill, I asked this earlier of our revisor. In the bill on page 3, line 15, there is, I guess, a definition or partial definition of prohibited sexual activity. And it reads, means as specified in military regulations, inappropriate physical intimacy under circumstances described in such regulations. So it specifies that the definition of this is in military regulations, but it's not described in this bill. So I'm curious as to what is the definition?
Sure. So that can take many different forms. So some of these forms you will see that we actually have in the bill, like recruiters can't have inappropriate or any sexual relationships with recruits, or, supervisors can't, leverage their position as a supervisor to get sexual favors. And so some of those you'll see in there. But what I think you're specifically referring to is you would find in the Army regulations would be in Army Regulation 600-20, Chapter 4. And there we're looking at relationships between people with disparate ranks. So an officer should not be dating an enlisted. A senior enlisted should not be dating a junior enlisted. And so the point of that is we try to keep things separate and impersonal enough that when an officer has to tell somebody to go do something hard, they can do so. And it protects the professionalism and the integrity of the workplace.
I remember adultery being one of the.
Yes.
Right? Is that still?
And I actually think that, and I can get back with you, but I still think that that's a misdemeanor just in Kansas writ large. So I don't want to misspeak. I could get back with you on that, but
how big that definition was. Thank you.
Yes.
Senator Dodson. Any other questions? Any other questions? Yes, Senator Black.
Thank you, Mr. Chair. Thank you for your presentation. When we're talking about UCMJ, well, let's take, for example, a person comes into the Army or Air National Guard, and they have not had any prior military experience. So you're going to send them at some point to basic training and then AIT. How much, and I don't want to say indoctrination, how much education do they get in UCMJ as it would pertain to them when they're first coming into the military? Yeah, I mean, is it like a 2-hour course, part of the curriculum when they're going through, or how does that work?
Mm-hmm. No, that's a great question. So in the Kansas National Guard, when you have someone who's basically in that window between having, taken the oath and signed on, but not having gone to basic training yet, we call it the RSP program, and they go and they drill just like anyone else in the Guard does. And during that period of time, we use that as an opportunity to teach them and kind of give them a head start into Army culture about, KCMJ, our rules on fraternization, our rules on, how you interact with people. And so we use that as an opportunity to kind of get people up to speed before they actually hit basic training. For like the Kansas National Guard writ large, we have a requirement to go and brief units once a year on KCMJ, on sexual assault, on sexual harassment, to make sure that, the rank and file is up to date and they understand what the rules and what the expectations are for how they are to comport themselves while in a duty status.
Okay. And just like something like this, what we're doing now is basically updating the Kansas UCNJ part of it. Are you going to then in turn have a briefing or something for the troops under that command to say, here we're updating all of this and here's what you need to know?
Absolutely. every year we do an initiation course with every new commander where like a JAG will get an opportunity to go talk with all the new commanders and first sergeants and say, hey, look, here's the Kansas Code of Military Justice. Here's the Uniform Code of Military Justice. But if we're lucky enough to get this to pass and become law, then we would take it upon ourselves to go and do training across the state to make sure everyone knows. Because, you know, a handful of attorneys know, fantastic, great. That doesn't really do much. We need to make sure that, you know, the 7,000 serving in the Kansas National Guard are aware of, you know, the new left and right limits. But this won't strike them as terribly new because they're all fairly familiar with the UCMJ already. So when we go and talk to them, they'll say like, well, yeah, because I read about that. And just to be honest with you, a lot of them don't always necessarily appreciate the distinction between the KCMJ and the UCMJ all the time. So one of the benefits of making this more similar is it's going to erase confusion and ease confusion amongst the rank and file because so many of them are already so much more familiar with the UCMJ. A lot of them have come off of active duty. A lot of them have deployed, and that's where they really got to experience it. But yes, we will teach them, but I think actually this will make training even easier because there's already a level of familiarity with the UCMJ.
Thank you, Mr. Chairman.
Any other questions? Any other questions? Well, thank you. Thank you very much for doing this.
Thank you.
We'd like to thank all the rest of its staff being here, giving backup, doing flanking action. Oh, amendment? I don't know. As chairman said that we can do anything. Okay, yes, we'll allow an amendment. Let me go ahead. Would you please discuss the amendment?
Happily. So, Mr. Chair, committee members, before you is a proposed amendment to House Bill 2392. And the bulk of this or a lot of this is just simply cleanup and making things a little more clear. So if we look at page 2 and line 22, we talk about how under the Article 15, a soldier has a right to appeal the Article 15 decision that a commander makes, but they only have one appeal. So under that under that idea, everyone gets a chance to make sure that if they disagree with the commander's decision under an Article 15, they get to have a higher level of command and another staff judge advocate look at it to make sure that they've been treated fairly and that the decision was just. Then at the bottom of page 2 is just minor changes to clean up the bill and make it read a little easier. Page 3, line 13 is the definition of military recruiter. We're changing it so it says that it has that the military recruiter has a primary duty to recruit persons for military service, which we think is a better definition of military recruiter. Page 4, and this is probably the most substantive change that you'll see. New section 5 is sexual harassment in the military. And the original language, we used the language from the EEOC and the CFR, but in keeping with our idea of staying consistent with the UCMJ and with what the military has published, this new definition reflects what the executive orders in the UCMJ says about sexual harassment. So this is done to be in conformity with the UCMJ. And so we have shifted this language so it's a more accurate reflection of what the UCMJ and the executive orders say about sexual harassment. We go to page 6, which is the next page of the amendment. In section 15, here's where we're talking about simple assault in our definition of simple assault. And if I could just talk about why this is important to the Guard for a second. Sometimes we'll run into incidents where something happens within a unit, maybe at formation, maybe two soldiers get in a disagreement and there's a shoving match or something like that, where it's not serious enough for civilian law enforcement because they have 100 things going on to investigate. But it's a real problem within the unit for morale, for cohesion, to ensure that people are focused on the mission. And so what we wanted to give commanders the ability to address this and square this up immediately and not have to ask of civilian law enforcement to handle something that they're probably going to be too busy. And so while something might not be important enough for, a sheriff's office to handle something, it could cause big problems within the unit. So when we're talking about simple assault here, we just want to make sure that the commander has the ability to keep unit cohesion and keep people not being distracted from the mission. All right, so page 7, we're cleaning up what intimate visual image means. So we're changing that to private area of a person. Move on to page 9. This is where we're trying to clean up the language for where someone is using, trying to unduly influence the commander. And we think that with graft or bribery. And so we're trying to clean that up and make that language a little stronger and a little clearer. And then page 10 is just a couple of small cleanups to include UCMJ Article 120. Page 12 is on section 34. We just want to make sure that it's clear that disobeying a lawful order will be punished. So this isn't so much a radical change in philosophy or theory. It's just making sure that the language is just a little clearer. And then finally, we tried to, on page 13, make the definition of judge advocate a little clearer as well, because we helped her draft the bill, so obviously that's near and dear to our hearts. But those are, Mr. Chairman, that's the substance of the amendments.
Thank you. Are there any questions? Questions at all? Amendment and the bill on Tuesday. Thank you.
Thank you.
Do we have any opponents? Do we have any opponents? Do we have any neutrals? Not. Close the hearing on House Bill 2392. We're going to go into final action on HB 2230, updating statutes relating to the Kansas Army and the Air National Guard and providing for the appointment of a state judge advocate. We don't need to review this. You should know that. Have a motion to pass this bill. Representative Goddard.
Mr. Chair, I lost a bubble here. Were there any amendments on this bill?
They were? Oh my goodness. So, could you? Advisor is going to go over our amendment. Thank you for catching that.
Committee, this amendment was, I believe, passed out on Tuesday with the bill. And it, excuse me, on page 1, there is 2 additions in line 17. After assistant, we insert state. And on line 22, we struck, the bill is 30. That is struck and insert 20. Page 2, line 32, after the which, insert and.
That's right.
And on page 3, from line 36 to line 43, all of that language is struck. On page 4, line 1 through line 6, all of that language is struck. On line 8, after appoint, the stricken language, insert assign the number of, and then continue to strike language until line 29, where you insert from the ground forces and air forces of the state who are authorized by National Guard Bureau rules and regulations. Sub B, the assistant adjutants general shall, if they qualify therefore, hold military rank as may be authorized and approved for the positions by the National Guard Bureau of the United States. The assistant adjutants general, at the time of their appointment, shall have served at least 5 years as commissioned officers in the Kansas Army or Air National Guard. Sub C, the assistant adjutants general shall serve at the pleasure of the adjutant general and perform such duties as are assigned by the adjutant general, period. D, the adjutant general shall designate one assistant adjutant general as the senior assistant adjutant general who, during any period when the adjutant general is absent, unable, or by express direction of the adjutant general, shall perform the duties of the adjutant general as acting adjutant general. And then, same page, we insert a new section, which was an attachment at the back of the balloon, where we insert new language regarding the United States Property and Dispersing Officer and their duties under this statute. Then going back to page, and then on page 8, in line 21 and 22, we insert the sections that were mentioned before, or statutes, pardon, and that's the amendment.
Is there any discussion on this? Okay. Representative Goddard.
Well, in that case, Mr. Chairman, I would move that we pass out House Bill 2230. Oh, we got to do the amendment first. That's right.
I'm glad we're working together.
Okay. I would move approval of the amendment.
Mayor, second. Representative Collins. We have any more discussion? All in favor, say aye.
Aye.
Opposed? Amendment passed. Now back on the bill.
Thank you, Mr. Chair. I move the committee forward House Bill 2230 as amended favorably for passage.
Representative Weigel, seconded. All in favor, say aye.
Aye.
Opposed? Passes. Thank you. Now, on House Bill 2378, authorizing the Secretary of Administration on behalf of the Kansas Department of Aging and Disability Service to convey lands in Shawnee County to the Kansas Commission on Veterans Affairs. There were no amendments on that. Any discussion on that? Any discussions, questions? All in favor, say aye. What? I'm not supposed to do something else? It would help to have a motion. Representative Younger.
Thank you, Mr. Chair. I move the committee recommend House Bill 2378 favorably for passage.
Thank you. Do I hear a second? Second from Representative Hill. Now, any discussion? All in favor, say aye. All opposed? Will do. One no. Thank you. The bill has passed. And I'd like to do some announcements. Our next meeting will be February 21st. We have to do some checking because we had our majority leader tell us something a little bit different, a difference of being on the floor all day. So we might have a change. We will have a briefing from the Department of Revenue and final action on HB 2392. So do I hear a motion? Yes, sir. Yeah, Representative Johnson.
I wish to apologize for my phone, and I'd like to know what you would like for reparations on our next committee meeting.
Do I hear a motion for chocolate? Motion by Representative Ruiz. Do I have a second? Do I hear a second? A second by Representative Butler. All in favor, say aye. All opposed? There it is. Do I hear a motion for adjournment? Motion for adjournment. I know we're having too much fun here, but Representative Butler, do I hear a second? Representative Weigel, all in favor, say aye. The motion has passed. Oh, anybody opposes? I don't think so.